If the appellant's ready, you may begin.
Good morning, Your Honor. Scott Tschirhart on behalf of the Maverick County defendants. May it please the court. This case involves a constitutional county judge holding a member of the public in contempt during a commissioner's court meeting and other commissioners being sued for money damages for failing to stop the judge from holding this person in contempt. The trial court below erred in a number of specific ways that should allow for this court to reverse and render. The trial court should have recognized that Texas judges are entitled to 11th Amendment immunity. The trial court should have recognized that Judge English Cantu is entitled to judicial immunity in his capacity as a constitutional county judge. The court should not have extended bystander immunity beyond the scope of the law enforcement context, and the court erred in its analysis of qualified immunity claims of the appendant. As I say, the court should reverse and render the court's opinion and should dismiss this case entirely. This court has repeatedly held that Texas judges are entitled to 11th Amendment immunity. Davis versus Tarrant County in
Counsel, obviously this is, as you identified helpfully at the very beginning, this is a constitutional county judge. My understanding that the judicial functions and the judicial understanding of what immunity would apply to are very few for a constitutional county judge. This county judge was presiding over a commissioner's meeting, which at least on its face would sound like not a judicial function. So why would judicial immunity apply to this? It seems to me a principal argument is because holding somebody in contempt is a judicial function. Is that the response?
A little bit more complex than that, Judge Southwick. Article 5, Section 1 of the Texas Constitution says the judicial power of the state shall be vested in one Supreme Court, one Court of Criminal Appeals, in district courts, in county courts, meaning constitutional county court, in commissioners' courts, and in courts of justices of the peace and other courts that may be provided by law. So commissioners' courts is a repository, according to the Texas Constitution, of judicial power.
Well, regardless of what it's issued, it has to be using it. And a commissioner's court meeting dealing with non-judicial matters would not be, it seems to me, a very good place to be saying judicial immunity would apply. Why was what the commissioner court was doing and the county judge judicial in nature, other than the argument that holding somebody in contempt somehow brings judicial power into play?
The county court, the constitutional county judge, wears a number of hats, as you know, Your Honor.
What hat did he have on at the time of the action relevant here?
Had on his judicial hat at that time, Your Honor.
Why?
Because there was direct contempt.
Okay, so that's I guess I'd be getting to what I started with. It seems to me your only real argument is that even if the rest, I mean, are you conceding? You don't like the word concede, I guess. Would you acknowledge that the rest of what was happening there were not judicial acts? It was only the holding of this person in contempt that arguably is a judicial act.
I would acknowledge, Your Honor, that the subject matter of the commissioner's court meeting did not involve judicial acts up to and until the time when there was this direct contempt that was witnessed by the judge. At that time, he changes hats and takes on his role as the leader of the commissioner's court, and he is empowered under the Texas Constitution to issue such writs to enforce his jurisdiction, to keep order here. At that point, he becomes a judicial officer, and he takes a judicial act in holding this person in contempt.
Can the administrator, is there no other state authority to the head of an agency, to the head of anyone who would be holding public meetings, to hold someone who is disrupting the proceedings in contempt?
Well, and that's...
I'm basically arguing if anybody has that authority who will always be protected by judicial immunity, even if the person is nowhere near the category of being a judge?
I don't think so, Your Honor. I think it has to be a judge. A judge is a unique person.
It has to
in
be a
our
judge to hold
jurisdiction
somebody in
system.
contempt, or it has, is that your point, that no one in Texas can be held in contempt at some sort of public meeting, at an agency meeting, at a county commission meeting, except a judicial officer?
I think that the Texas legislature has held people in contempt, but that's a different statute altogether. It's a statutory power. In this case, there is a statute that deals with contempt.
At a commissioner's meeting.
I'm sorry, sir.
There's a statute that deals with contempt at a commissioner's court meeting.
That's
And
correct.
it says the commissioner court itself, the commissioners,
I don't believe
can
that's
punish somebody for contempt.
I don't believe that's what that statute says, Your Honor. I think that statute is a limitation on the amount of punishment that can be given to someone under
It does say that.
It says the Commissioner's Court shall punish someone no more than $25 fine.
It doesn't say the county judge shall punish somebody no more than.
It does not say that the county judge shall not. But under Section 16 of the Texas Constitution, the county court has jurisdiction as provided by law. The county judge is the presiding officer of the county court and has judicial functions as provided by law, and the county judge shall have the power to issue writs necessary to enforce their jurisdiction.
As a county judge in court, it sounds like.
But the county judge is also the presiding officer over the commissioner's court. It wouldn't make sense for the commissioner's court in a direct contempt proceeding to be able to vote on a contempt. Because in a direct contempt proceeding, the judge witnesses the contempt that occurs right in front of him. It complies with due process to go ahead and issue a citation and a punishment under those circumstances because there's no facts to find. Mm-hmm. If the Commissioner's Court wanted to hold somebody in contempt, they are subject to the Texas Open Meetings Act, meaning that they would have to put it on this is an item on an agenda, post the agenda, 72 hours would have to pass before they could take it up, and then it would be voted on at that time. Direct contempt is very different. Direct contempt happens directly in front of the judge, and the judge needs to have the power to control that.
Well, wouldn't, under your theory, anytime a public official becomes a presiding officer of a meeting, he can become a judge to punish people who are disrupting the meeting. And this would apply, I guess, to the Speaker of the House of Representatives. He could just all of a sudden become a judge. And
I don't think that just being ahead of a meeting transforms somebody into the position of a judge. A constitutional county judge is a creature of the Texas Constitution. He's elected to that office. It's not like, the same thing applies to a JP. The U.S. Supreme Court in Fisher versus Pace said historically and rationally. I'm sorry.
Once someone becomes a constitutional county judge, everything he does is judicial.
I don't think that's correct. I think he wears a number of hats, Judge Dennis. I think that there are certain things he can do that are administrative. There are certain things that he can do that are legislative in nature. But holding somebody in contempt is specifically a judicial act. And he has the power to do so under the Texas Constitution. One of the issues that the court below struggled with is that she was constrained. Congress has constrained federal judges. They have specific powers in direct contempts, and those are restricted to very specific instances. Texas courts are not so restricted. Texas courts allow what the common law used. A direct contempt, you can punish somebody for that if it's done in front of the court.
Well, these county judges, constitutional, I'm not from Texas, and so I assumed that they were mostly executive type officers who helped administer and run the affairs of the commission or the county. How do they act? Do they actually try cases in addition to that?
In certain counties they do, Your Honor. In certain counties they try misdemeanor cases. And then you have, of course, your county court at law, which is created by the
They're
legislature.
trying these cases, it's pretty clear they're acting as judges, judicial judges, and not administrative, executive officers. But in our case, it's not that clear, is it?
I agree with you.
This was
Your Honor.
not a trial, a judicial trial going on. This was a commissioner's meeting or something like that.
I agree, Your Honor, that it's not as clear as if he were trying a case in front of the court. But this provision that's in the Texas statutes goes back to 1925. I think it's a limitation on the amount of punishment somebody can receive in a direct contempt.
When you say this provision or statute, you're talking about the one that says cannot be incarcerated longer than 24 hours and whatever the dollar amount is?
That's correct, Your
Goes
Honor.
back to 1925.
That's correct. And you would think that there would be more case law on it. Unfortunately, there isn't.
There are two cites under it, both to this case from the district court.
I apologize, Your Honor.
I was looking up this statute, and the only cites to it are the district judge's ruling in this case, the only interpretations of it.
That's what it looks like, Your Honor. And under that circumstance, it leads right into the argument dealing with qualified immunity. If there are no cases out there that are on point of something analogous, there's nothing to tell this judge that he can't hold this person in contempt under these circumstances. I think the judge is entitled to 11th Amendment immunity because he's a county judge and he's serving that function. I think that he's also entitled to judicial immunity because at that particular point in time, he was committing a judicial act. Holding someone in contempt is very clearly a judicial act. It was in his courtroom. It was, of course, it was during a county commissioner's court meeting. But he consulted with the county attorney before he issued a citation, and obviously he's trying to do the right thing. Wasn't like he pulled this out of the thin air. But I think even if you find that he exceeded his authority, he's entitled to qualified immunity because there's no case that's on point that says he can't do this.
Well, usually it's a two-step process, and you don't get into clearly established law until the second step. Potentially, we'll have to make a decision here, but if the person is acting within the scope of his or her authority, you then look as if at the act of whether it violated clearly established law. But you don't look at whether the scope of the authority was clearly established. That seems to be independent. And I don't know if you cite any cases to us that whether it was clear applies even to the issue of whether it's within the scope of the authority.
Yeah.
So it's two different steps, and you're making the clarity of the law apply to both. And I don't think there's case law that says that. It doesn't mean that it's not the right result, but you haven't cited us anything.
And I can't cite you to case law that says that. But I can say that there's a hierarchy of judges that are set forth in the Constitution. The JP court is below a county court at law, and they lay it out from the Texas Supreme Court, Court of Criminal Appeals on down through that. And this court has found that JP courts are entitled to judicial immunity on a contempt citation.
Okay.
And in that case, someone was coming to visit the judge based on he wanted to see complaints that had been filed, and he wasn't actually before the judge on a particular matter, and he certainly wasn't a defendant before the court. And yet this court upheld that he had judicial immunity in the act of holding this person in contempt because it was an act that a judge does. We're looking at the function of what happens here. I'm very close to the end of my time. I'll reserve others for the later part.
All
Thank you,
right,
Your Honor.
Counsel.
May it please the court, my name is Matt Manning and I have the distinct honor of representing Ms. Enriqueta Diaz. This is a simple case masquerading as a complex case. It's a simple case because the statute, section 81.023 of the Texas Local Government Code, expressly confers the authority upon the Commissioner's Court to hold someone in contempt at a Commissioner's Court meeting.
But as I read that statute, it actually says the Commissioner's Court shall impose punishment, you know the language better than I do, with these limitations. It doesn't say that the Commissioner's Court is the one that holds the person in contempt. It's just the one that imposes sentence. How does that affect your analysis?
That's correct, Judge Southwick. And first, in our briefing, we actually addressed that contingency. So we said even in the event that you believe there's a nebulous question about who can actually hold someone in contempt, Judge Cantu cannot unilaterally punish because the statute is clear, at least in that respect. But beyond that, the first thing I want to say is my esteemed colleague unfortunately spoke incorrectly. This statute has actually been on the books since the first codification ever of Texas revised statutes, 1879. That's probably why it hasn't been adjusted for inflation.
Is the language the same, or is there any significant difference?
It's precisely the same, Your Honor. It was actually codified as Article 1514, Section 11. And in that section, Your Honor, it says precisely this under the subheading Duties and Powers of the Commissioner's Court. The reason that's important is if you look at some contextual statutes that confer certain authorities on the county judge, for instance, the statute that creates the county court, it expressly says in that statute that the county judge acts as a judicial officer. However, in this context—
Are you talking about statutory county judges, county courts of law?
Yes, Your Honor, that create the constitutional county courts at law, because as Mr. Tschirhart mentioned, in Texas, you've got constitutional county courts at law, and then you have statutory county courts at law. The county judge, Judge Cantu in this case, in this particular county, actually has original jurisdiction over probate matters and misdemeanor matters. But when he is in the context of the Commissioner's Court, he's acting as the county CEO. He's acting as Mayor Cantrell. He's acting as any other person who's elected to oversee the county governance.
So your opponent basically says that presiding over the meeting, he refers to hat, I guess I'll refer to it as judicial robe. His judicial robe is sitting right there, and if somebody else needs to be held in contempt, he puts the robe on and holds the person in contempt. He's got that power, and a mere presider of a meeting wouldn't have that power. Is that a power that other presiders over meetings have in Texas to hold someone in contempt?
Not that I've seen, Your Honor, no.
Well, it does sound to me as if there's something unique about the county court, the constitutional county judge presiding over the Commissioner's Court, maybe having a power that other presiders don't have, and it looks like a judicial power.
Well, Your Honor, at first, I think the genesis of that argument is that the creation of the county judge position comes from the judicial department. But as Your Honor spoke to essentially in your question earlier, the real question is what is the actual function being performed? That's what the United States Supreme Court said in Stump v. Sparkman, and that's what this court has said in Davis v. Tarrant County. Which
Well, the meeting is executive and not a judicial function, I would allow you. Though, as I think about this more, maybe he'll convince me to the contrary, but I don't think so. But once contempt is being held, the role of the judge changes, is the argument. I'm not saying I'm on board with it. And so the robe is put on to hold somebody in contempt. Why isn't that a fair way to look at this?
Well, respectfully, Your Honor, that's essentially an argument that I think is convenient to try to advance the argument here, but it does not.
Some purchase to it. It's convenient, but a lot of winning arguments are convenient.
Sure, Your Honor, but it doesn't track here. And the reason it does not track here is because the definitional statute that creates the Commissioner's Court says that the Commissioner's Court is comprised of the county commissioners and the county judge. So if you look at that definitional statute in tandem with this one, you cannot read it where the county judge can ever be extricated for the purpose of a commissioner's court decision at large. If that were the case, there would be no reason to have any other county commissioners, because he could come in and say, I step into the seat of the full commissioner's court, I'm going to do whatever I think is appropriate, and that isn't how it works. In fact, in the court's order from the district court, the court referenced the testimony that was adduced in the preliminary injunction hearing, and the county judge there testified that what would happen or should have happened essentially is that the commissioner's court could have put it to a vote, and the commissioner's court could decide to hold someone in contempt. Now, he did at the end say he's the ultimate authority for that, but it doesn't become a judicial function because he's the one doing it. That right is conferred to the whole
What you said
body.
makes sense. Is there any statute, any established rules for how that's done, or is that just an explanation by your witness that it should have been put to a vote?
Well, that's an explanation by the witness, Your Honor, and that's one of the problems, is there is a dearth of litigation on this particular statute. However, if you read, as I mentioned, if you read the definitional statute for the commissioner's court at large, it includes the county judge. So there's not a reasonable reading of that statute that would say the county judge in and of himself can make that decision.
Well, but make the decision to hold somebody in contempt. All the statute says is the punishment. So it's not necessarily inconsistent with the statute that the county judge by himself or herself could hold somebody in contempt.
I suppose the court could get there, Your Honor. I mean, to be frank, there's never been a construction of that. The reason that's an issue, however, is the Texas Supreme Court in 2023 determined that when the county judge is sitting over the commissioner's court, he's acting in an executive function. There are many references to that in these statutes as codified in 1879. So the reason that creates the issue of it doesn't become a judicial function just because it's the county judge doing it, is because if the Texas legislature intended to confer that authority on him, they would have done so. Instead, they gave it directly to the commissioner's court here, and irrespective of that, even if there's a question about who can hold her in contempt, he most certainly cannot unilaterally punish her for that contempt. That's the genesis of the Fourth Amendment claim. Because what happened in this case, as Your Honor surely know from the record, is it was a discussion during public comment. So the first thing that's important to note is that if you look at the Davis factors in this context, there's no case in controversy. It's not what Mr. Tschirhart and I are doing right now. It's instead citizens who get up and say, here's my position on what the county is intending to do with this debt, right? And once that happened, through the course of that contact, there was some tensions that arose, and she was threatened to be held in contempt. And then he said, I individually hold you in contempt, and then conferred with the county attorney and issued an order in his own name instructing her to be taken to the jail. That's not the commissioner's court at any point of this.
What effect does getting the legal advice have on the claim?
I don't think it has any effect on the claim, Your Honor, and the reason is because the question is really, as the court knows from Douthit v. Jones, does he have a reasonable belief that this comes from his lawful authority? No, he doesn't. He frankly testifies that he knows this needs to be a decision made by the collective body. I think the county attorney giving him that advice does not absolve him, number one, of the original contempt, because the problem here is she was already in custody at the time he consulted with the county attorney.
Well, this briefing, it says that she was held outdoors in the rain for 3 hours. Is that, am I conflating things that happened? It was raining, she was held for 3 hours, but she was not held in the rain?
No, Your Honor, she was in fact held outside in the rain, from my understanding. And then after the order was issued and after there was a conference with the county attorney and I believe also the sheriff's office, she was then taken to the jail where she was booked in and released. So the point is, she was already in custody at the time he sought authority from the
It's
county.
been hours behind bars, but it was the holding before she was taken to the jail to be booked that you're counting as the detention?
The first detention, Your Honor, yes. Well,
The only detention?
the beginning of the detention. Correct, Your Honor. The beginning of the detention, because that detention continues throughout the time she goes to the jail and is booked in until she's released from the jail. So it's one detention, but that's the beginning of it, and that precedes his conference with the county attorney. So as it relates to judicial immunity, we submit to the court judicial immunity does not apply here. All of the precedents that we've provided in our brief, both from this court and the United States Supreme Court, say that you ask the question of what is actually happening. I think Your Honor kind of alluded to that in one of the questions to Mr. Tschirhart, And frankly, he's not acting as a judge. He doesn't become a judge to put on this contempt hat. He's acting as the CEO of the county throughout the entirety of this contact.
It seems to me it's arguable, it's unclear. It's arguable that it was unclear if he had this power. So how does that affect qualified immunity?
No, Your Honor, it does not affect qualified immunity. And the reason is because, first, he testified that he thought what we submit should happen is what should happen. I mean, the question is really, what are the alternatives? And the alternatives are, here, you put it to a vote, the same way you're putting to a vote whether you should put stop signs at certain intersections.
Well, that testimony was months or even longer later. It's what, at the time of the action, this defendant knew, and if it was unclear whether he had the authority to do what he did, doesn't that affect qualified immunity?
It does not in this respect, Your Honor, because here, he's already on notice. What we provided in our briefing, as I'm sure the court saw, is we provided analogous circumstances in your sister circuits and in the United States Supreme Court that stand for the proposition that regulations or statutes can be the clearly established law for the purpose of putting someone on notice. In particular, as it relates to United States v. Lanier, that's a criminal case that's construing the criminal civil rights statute. The Supreme Court has said, look, the fact that the law is on the books gives adequate notice, and that is tantamount to the clearly established question you have in the civil rights context. So our position is here, you don't need some numerosity as it relates to cases to establish that he should have known because the law was already on the books. The public policy behind that, however, is if you did not find that in this case, then you could theoretically say that no criminal defendant could ever be held accountable if he or she said, I didn't know that law was on the books. I didn't know I couldn't do that. That might work for Steve Urkel, but it does not work in courts of law. And the reason in this case that it's appropriate to recognize that qualified immunity is not something that should be extended is because a reasonable reading of this would give him the understanding he does not have the statutory authority to hold her in contempt. Moreover, the other question in that analysis is are the objective circumstances at the time? And as I've told your honors, this law has been on the books since 1879. So 144 years before this happened, it was already on the books, because it was 2023, that the commissioner's court was the one that had to punish. And our argument is the one that had to hold her in contempt. Since that did not happen, he's on notice, and clearly established law is already provided by the fact that the statute is promulgated. And to delve into that just a little further, the examples that we provided the court are examples from Pennsylvania and Delaware, both of which the court, the Third Circuit, found that those statutes being...
I would have thought that without more law on the books, that the commission would have to agree to pursue this person for contempt, but that they would have to go to a court in order to get the contempt proceeding and to punish the person. Is there anything in the law that we have governing us that says anything like that?
No, Your Honor, that's a great question. And no, I have not seen anything that says essentially the commissioner's court would take a vote and then refer it to a subsequent court for a finding of contempt. I have not seen that, Your Honor. I haven't
Would
seen
you address bystander liability?
Yes, Your Honor. So as it relates to the bystander liability, obviously this court in Whitley v. Hanna in 2013 said essentially that, an officer who knows an officer is violating someone's constitutional rights can be liable if they don't intervene. Our position is here.
Now, officer there meant police officer, a law enforcement officer. You want to expand it to public officials generally, it seems to me.
I do, Your Honor, and I suspect the court may be reticent to do that. I think if the court were inclined to do so, it could do it in this case to the extent that it set the rule around any express conferral or authority or any express denial of authority, meaning the rule could be extended to say it doesn't have to be a law enforcement officer. However, a public officer where there is a direct statute, authorizing their action or not giving them certain action, then the rule could be extended that way. And the reason that might make sense is in the law enforcement and in the excessive force context, there are always questions about how quickly things need to happen. They're rapidly evolving about whether somebody can do something or not. And most of the time, there's not a direct statute that says an officer may or an officer may not. This is a different situation. It's different because you have an express statute that says the body that has the authority to punish, and as we're arguing, the authority to hold someone in contempt. So the same logic that applies to Judge Cantu as it relates to he should be on notice at this time that he could not do this action would apply to any other commissioner, because as our brief shows, there's testimony there from another commissioner who testified, one, County Judge Cantu is not the commissioner's court by himself, but two, they go to an institute, basically baby commissioner school as they call it, to learn how to be a commissioner and learn all the attendant statutes relevant to being a commissioner. It stands to reason one of those attendant statutes would be the statute concerning contempt, right? Considering it's likely that some kind of potential contemptible conduct may come up in a commissioner's court meeting. So they have to know how to respond to that. And what's important in this case is factually, there is one commissioner who attempts to intervene. So I think you can deduce from that that at least that commissioner and the other commissioners knew that they could not allow him to unilaterally hold her in contempt, which is why he tried to intervene. As such, we think that bystander liability can be extended to this case because this court said in a footnote in Whitley v. Hanna that it was not foreclosing the possibility that bystander liability could be extended outside of the non-excessive force context. And I respect that, courts do want to make sure that you're moving incrementally and not making too wide a swath with changes. But I think that could happen if the rule were to be cordoned to the express circumstances where you have a particular law that applies to certain conduct. Because here it's unequivocal. Here it says exactly what the commissioner's court can do in terms of punishing someone with relation to contempt. And you can deduce from that what cannot happen, which is that an individual cannot unilaterally hold someone in contempt. Accordingly, we think that bystander liability can be extended in this circumstance. Also, as it relates to his sovereign immunity argument, this court said in United Disaster Response in 2007, I believe, that counties and parishes are not arms of the state for the purposes of sovereign immunity. So from the 11th Amendment perspective, that argument is functionally dead in the water because this court has said a county is not the state, essentially, for the purposes of sovereign immunity. And it's interesting that the other case was actually argued right before ours because they talked about district attorneys. As your honors surely know, in the state of Texas, sometimes district attorneys and district judges actually preside over districts that subsume multiple counties. The county judge is different. The county judge's authority only extends to the territorial limits of his or her individual county. So that means the real party in interest can never be the state of Texas because he's never really representing the state of Texas, irrespective of the fact that the county is a subdivision of the state of Texas. He's always representing the county, which means under this court's own precedent, there's not an 11th Amendment sovereign immunity that immunizes that action. On the state side, as you notice in our briefing, the state of Texas has, as it relates to its sovereign immunity, if you are doing an ultra vires act, meaning you don't have the authority within your power as a public official to do a certain thing, then you aren't cloaked with sovereign immunity. On the state side, it's precisely the same here because our position is he did not have the authority to do what he did. Accordingly, he cannot be immunized from a sovereign immunity standpoint. With respect to qualified immunity, as we've mentioned, the right here was clearly established. The Fourth Amendment right, as we've pleaded in our amended complaint, was found by this court in 2007 and far before that in Freeman v. Gore that you have the right to be free from an unlawful arrest without probable cause. What's a little bit thorny in this case, but is nonetheless the crux of our argument, is the probable cause here is really tantamount to a conditioned precedent, and that being the commissioner's court has to make a decision as a body. If they've got the quorum, if they're there and they can vote on any other matters, they would have to do the same here to hold her in contempt and clearly from the statute do the same here to punish her. Without that, her arrest and her detention is without lawful authority. It's not ameliorated by the idea that he puts on his hat and becomes a judge for the purpose of finding her in contempt. He's acting as the county CEO. And this is functionally a question of whether Mayor Cantrell could arrest somebody at a city council meeting. The same way she should not be able to, he is not able to because the statute does not confer upon him that authority.
What's the penalty under this arrangement for contempt? What's the maximum penalty?
Up to a day in jail or up to a $25 fine. And with that, we would ask that the court affirm the decision of the district court below, extend bystander liability in this circumstance, find that qualified immunity does not apply, and also find that judicial immunity does not apply, as Judge English Cantu was not acting as a judge. I thank your honors for your time and attention, and I cede the rest of my time.
All right, counsel, thank you.
May it please the court. I'd like to direct the court to the case of Kastner versus Lawrence, 390 Fed App 311, where this court rejected the argument that a JP, a justice of the peace, in issuing a warrant was acting in an administrative, legislative, or executive capacity. The court noted that under Texas law, the waiver of immunity under the Texas Tort Claims Act did not apply to any claim based on an act or omission of a court of the statute or any person acting in an official capacity or judicial function of a governmental unit. The state of Texas has waived immunity to sue counties, but has not waived immunity to sue judges. The plain text of Section 81.023 of the Texas Local Government Code says, and I'm going to quote this, "The Commissioner's Court shall punish a person held in contempt by a fine of no more than $25 or confinement for no more than 24 hours. A person fined under this section may be confined until the fine is paid." My friend on the other side has pointed out that the statute is much older than I thought it was. And I'd have no doubt that he's correct on that. But the statute contains no procedure, no vote required of the Commissioner's Court, no rules that affect the way contempt is found. There's nothing in this statute except a limitation on how much punishment someone may receive as a result of contempt. I'd like to talk about bystander claims. Well, first, let me get some clarification. A 12b-6 should be confined to the pleading that is on file, the live pleading. But my friend on the other side referred to testimony at a prior hearing, prior to the motion to dismiss hearing. At that same hearing, the plaintiff testified that she wasn't held outside in the rain. She testified that she was removed from the courtroom and that she went to a restaurant and that she later got a call to go down to the sheriff's office to be booked in. There's some discrepancy there, but it really doesn't have a whole lot to do with what's going on here, but it's certainly she was not held in custody in the rain. On a bystander claim, how far could this go? Assuming a trial judge could violate somebody's rights under 42 U.S.C. 1983, and he commits an act in his courtroom that violates someone's rights, and other officers should stop him, would that officer include the bailiff? He's an officer of the court. Would that officer include the court reporter, who's an officer of the court? Could it include me? I'm an officer of the court when I'm appearing before the court. It could lead to ridiculous circumstances. This makes perfect sense in the context of a police situation where a police officer sees someone using excessive force, and this court has held that that's generally what this is, bystander liability is about. He has a duty to protect that person from having his rights violated. Do other officers, simply by their position as an elected official, have that same duty that a police officer has to prevent somebody else from having their rights violated? And how far should it go? I think it should be restricted to police work because that's where it makes sense. On the, because the footnote 11 out of Whitney versus Hale, this court said, although Hale often most often applies in the context of excessive force claims. Other constitutional violations may support a theory of bystander liability. And it cites to the Wharton County case. But it also says all law enforcement officers have an affirmative duty to intervene to protect the constitutional rights of citizens from infringement by other law enforcement officers in their presence. I could think of other violations of someone's rights that don't involve excessive force. An illegal arrest, for example. In certain cases, maybe a profiling of some kind based on racial or some kind of an ethnic determination. Those things you would expect a police officer to stand up and say, hey, buddy, don't do that. That's not right. Police should be policing their own, in other words. But how do you apply that outside of the police context? I see I've run out of time. Thank you very much.
All right. Thanks to both of you for bringing this case to us. Keep going.